Welcome to EUPrivacyForAll, Session 22 on GDPR, Article 46, Transfers subject to appropriate safeguards. Article 42 on the transfers by way of appropriate safeguards was renumbered Article 46, titled Transfers subject to appropriate safeguards. Basically, it lays down that in the absence of an adequacy decision, a controller or processor still may transfer personal data to a third country or an international organization only if it has provided appropriate safeguards and on the condition that enforceable data subject rights and effective legal remedies for data subjects would be available. In such a case, appropriate safeguards being ensured, no specific authorization from a supervisory authority will be needed in the following cases: a legally binding and enforceable instrument between public authorities, binding corporate rules, standard data protection clauses adopted by the Commission are used, or standard data protection clauses adopted by a supervisory authority, or an approved code of conduct will be used, or finally an approved certification mechanism. Such appropriate safeguards may also be provided subject to the authorization from the competent supervisory authority when contractual clauses are used between the controller processor and the recipient, or provisions are inserted into administrative arrangements between public authorities, including enforceable and effective data subject rights. The supervisory authority shall apply when necessary the consistency mechanism. Authorization by a member state or a supervisory authority will remain valid until amended, replaced or repealed, if necessary, by that supervisory authority. A key recital in the GDPR is recital 108. It displays that in the absence of an adequacy decision, the controller or processor should take measures to compensate for the lack of data protection in the third country by using appropriate safeguards for the data subject. Such safeguards may include and consist in binding corporate rules, standard data protection clauses adopted by the Commission or by a supervisory authority, or contractual clauses authorized by a supervisory authority specifically. The availability of enforceable data subject rights and of effective legal remedies will be the condition for such a data transfer to take place. Authorizations by the competent supervisory authority should be obtained when the safeguards are provided for in administrative arrangements that are not legally binding. In recital 102, it is clarified that the regulation is without prejudice to international agreements regulating the transfer of personal data, including appropriate safeguards for the data subject. The Directive lays down in Article 26.2 on derogations that Member State may authorize a transfer to a third country which does not ensure an adequate level of protection, where the controller adduces adequate safeguards with respect to the protection of privacy and fundamental rights and exercise of corresponding rights. The Member States shall inform the Commission and the other Member States of the authorizations granted. And if a Member State or the Commission objects on justified grounds involving the protection of the privacy and fundamental rights and freedoms of individuals, the Commission shall take appropriate measures. Where the Commission decides that certain standard contractual clauses offer sufficient safeguards, Member States have the obligation to take the necessary measures to comply with this Commission's decision. What should accountable data controllers and processors get prepared for? First, they should anticipate a substantial change in the assessment of appropriate safeguards and transfers, since once again the decision of the 6 October 2015 Schrems case leading to the invalidation of the safe harbor, changed the game. Transfers will be possible using appropriate safeguards without prior authorization from a competent supervisory authority, whenever legally binding and enforceable instruments between public authorities are used, or binding corporate rules, or Commission standard clauses, or national standard clauses decided by supervisory authorities, approved codes of conduct, or approved certification mechanisms. The transfers with prior authorization will apply to non-binding instruments, that is to say, contractual clauses not being standard ones, and provisions inserted into administrative arrangements between public authorities. The Commission, adequacy decisions, and Member States or Data Protection Authorities' authorizations regarding transfers shall remain in force until amended, replaced, or repealed. Those provisions apply without prejudice of the international agreements between the EU and third countries. So the question triggered now is about new international agreements. Will there be any new EU-US international agreement? The SHIELD will be validated or not? Working Party 29 specific guidance, EUCG upcoming ruling on clauses notably, and EU Commission or Data Protection Authorities' new sets of clauses.